Hi, and welcome to this Antiquities Trafficking themed Google Hangout. I'm Joanne McCafferty, and I'm completing my MSc in Collecting and Provenance Studies in an international context at the University of Glasgow. And at the moment, and for the next couple of months, I am working with the Smithsonian Provenance Research Initiative here in Washington, DC. This particular hangout will be centred on the strengthening and development of international norms in the realm of cultural property protection during armed conflict, which is definitely a topical issue worldwide at the moment. Over time, it has become customary in periods of conflict for cultural property to be destructed, looted, to fund army and rebel forces. Given the widely accepted view that the legally termed cultural property of each disparate nation is in fact the common cultural heritage of all mankind, international cooperation is necessary to enable the global protection and stewardship of said heritage. The following three hangouts discuss the international norms and rules born out of international conventions which have achieved varying degrees of success with regard to the protection of cultural property in times of conflict. Adrian Boss, the protection of cultural property during armed conflict has evolved over the relatively short period of the last 2 centuries. Broad international treaties for the protection of cultural property against destruction and looting during wartime have been drafted, ratified, and developed over time to achieve implementation on an almost global basis as regards the respect for our common cultural heritage, with such rules establishing normative ideals. I'm first going to discuss the rules governing the protection of cultural property against destruction and looting during armed conflict, and also their involvement by considering 3 pieces of legislation, namely the 1954 Hague Convention for the Protection of Cultural Property in the Event of Armed Conflict, the 1970 UNESCO Convention on the Means of Prohibiting and Preventing the Illicit Import, Export, Transfer and Ownership of Cultural Property, and the 1995 UNIDOA Convention on Stolen or Illegally Exported Cultural Objects, each of which have in turn acted to strengthen international norms. So in my final hangout, I will also address the importance of implementing these international conventions at a national level to further strengthen and consolidate global norms, as well as to the role of intergovernmental organisations, IGOs, in their successful operation to promote a global coverage around the protection of cultural property. The 1954 Hague Convention has, to a degree, established internationally accepted standards for the protection of cultural property against looting during armed conflict. Covering the matter of cultural property protection at source makes it the first port of call in the prevention of illicit trafficking in cultural objects. It was implemented as a result of crimes against cultural property during the Second World War. Refinement of the 1907 Hague Convention was necessary and led to a definite shield of protection for the tangible remnants of ancient and modern cultures, consequently strengthening international norms. For example, to reference Boss, legislation such as the 1954 Convention acts to modify the severity of war. Subsequent conventions and protocols act to refine the rules and accepted international norms by adapting to accommodate the ever-changing methods of war. The first rule to be established as an international norm in cases of armed conflict is defined by Article 4.3, which dictates that all nation-states party to the Convention should undertake to prohibit, prevent, and, if necessary, put a stop to any form of theft, pillage, or misappropriation of, and any acts of vandalism directed against cultural property. They shall refrain from requisitioning movable cultural property situated in the territory of another high contracting party. Even prior to the US's 2009 ratification of the 1954 Convention, its armed forces, according to David Meyer, had received training in its provisions for many years in accordance with the requirements relating to general protection on the level of customary international law. This blanket ban over all destruction or looting by any state party is imposed primarily via the display of a globally recognized symbol, a blue and white shield which indicates that cultural property is present. The creation of the blue shield in 1996 and the establishment of an internationally accepted standard of military training enacted in 1999 under Article 30 of the Second Protocol of the 1954 Hague Convention on the dissemination of the Convention facilitated the ongoing strengthening and development of the international norm established under Article 4.3. Nonetheless, Article 4 also provides the option to waive established protocols for the protection of cultural heritage, to quote Article 4.2 of the Convention, in cases where military necessity imperatively requires such a waiver. In the reality of armed conflict, this waiver favours military advantage over the protection of cultural property, deeming the Convention ineffective. This is primarily due to the lack of clarity in defining what constitutes such military necessity, and so there exists no globalised standard for this established rule. And so, to reference Wayne Sandholtz, whilst one party argues for one interpretation and application of the norms, other parties advocate different understandings. Moreover, with respect to the criminalisation of destruction and subsequent looting of cultural property at source, Article 28 states that the high contracting parties undertake to take within the framework of their original ordinary criminal jurisdiction, all necessary steps to prosecute and impose penal or disciplinary sanctions upon those persons of whatever nationality who commit or order to be committed a breach of the present convention. Secures the moral and ethical international norm of it being a criminal offence to destruct and loot cultural heritage during armed conflict. It is evident that there is no globalised prosecution model, and so the incarceration and punishment of any perpetrator falls to the single state and must be carried out under national jurisdiction. This is an issue when the perpetrator is from a non-cooperative state, particularly if said state has not ratified the convention. Such non-adoption and implementation of the legislation creates a barrier to the criminalisation of cultural property destruction and looting at source, becoming an international norm. As the enforcement of cultural property crime is problematic at a national level, a still developing legal instrument that will increasingly prove to be useful to fight cultural property destruction in the context of armed conflict is international criminal law. The varying degrees of compliance with moral and ethical norms established by the 1954 Convention among member states and the little or no compliance by non-member states highlights national legislation as having insufficient authority to bring to justice those accountable for destruction and looting. The next logical step for the implementation of the criminalisation of cultural property crime as an accepted legal norm is for offenders to be tried at the International Criminal Court, the ICC, at The Hague. According to Meyer, although its underlying principles may have reached customary international law, the actual mechanics of the 1954 Hague Convention's application have not led to the firm enforcement of the Convention and have failed to keep pace with the rate of destruction in the late 20th century. Given this increased rate of destruction and looting, particularly in the Middle East, the utilisation of the ICC could act as a major deterrent and consequently pose to strengthen and develop the rules and norms enacted under the 1954 Convention. Use was in fact made of the ICC in 2016 last year when Al-Mahdi, who belonged to an Al-Qaeda-linked group, and Zardine, was tried and convicted under Article 8 of the Rome Statute, which covers all types of war crimes, including damage to property which did not occur as a result of military necessity. Although Al-Mahdi was not tried under the 1954 Hague Convention, this is a step in the right direction, and with further support for the Convention being expressed through the UK's ongoing ratification, this Convention will gain greater influence worldwide. But I will be posting more over the summer on the UK's ratification and what it means for their future cultural property protection endeavours, particularly in Syria. In my next Hangout, however, I will be considering the 1970 UNESCO Convention and the 1995 UNIDROIT Convention have reached a level of customary international law and as well as transcended ethical norms. Thank you for listening to this Hangout, however.